So Keith, there's a little bit of confusion about documents that people have in an estate plan. Generally, in an estate plan, you're going to find a living trust, a will of some kind, generally a pour-over will that pours over everything into the trust. And then you're going to find some durable powers of attorney for assets and durable powers of attorney for health. And that's where people can make healthcare decisions for the settlor, the creator of this estate plan, or they can make asset decisions if the person's incapacitated in some form. We have clients that come into us and they're very agitated about powers of attorney after mom and dad have died, and that their brother or sister has power of attorney, and it's very scary to them. Can you walk us through the distinctions and differences between powers of attorney for healthcare and for assets versus a will and a trust?
Yeah, and it can be very confusing. A lot of times the opposite of that is true as well. Somebody will come in and say, I have power of attorney. Why is the executor doing this or that? So first of all, a power of attorney only applies, if it's a power of attorney for the management of assets, it only applies to non-trust assets. Anything that's in a trust is controlled by a trustee, so that's off the table. And the other thing that's interesting about a power of attorney is you think about what it is. So a power of attorney is where a person, who we call a principal, appoints an agent, and that agent is given certain powers. And that agent acts in the principal's shoes. So they can do anything the principal can do, subject to whatever their power limitation is. And it's as if they're the principal. So they can sign things, they can make decisions, they can write checks if that's part of their powers. But once the principal passes away, well, you can't stand in the shoes of somebody who's passed away, and therefore the power of attorney automatically terminates by operation of law upon the death of the principal. It simply no longer exists. So when you're looking at somebody who has a power of attorney versus an executor, the executor is going to win because the power of attorney terminates automatically at death. If you look at a power of attorney versus a trustee, the trustee is going to win because the trustee controls assets that are in a trust. So only assets outside of a trust would be subject to power of attorney. Here's something else that's kind of interesting about powers of attorney that a lot of people don't understand. Because the agent is standing in the shoes of the principal, a normal power of attorney also terminates upon the incapacity of the principal. So if the principal were to get in an accident and be in a coma, that power of attorney no longer operates unless it's what we call a durable power of attorney. And you referenced a durable power of attorney as typically being part of an estate plan. A durable power of attorney means that it still operates even upon the incapacity of the principal. That's why it's durable, I suppose. That's why we call it that. And that's why it's used in estate planning, because in estate planning, you want to think of every eventuality, which is what if somebody becomes incapacitated? What if they regain their capacity? And then what happens when they pass away? But even a durable power of attorney still terminates automatically by operation of law upon the death of the principal. That's just the basics of how a power of attorney works. An executor is a little different in the sense that an executor only acts once they're appointed by the court. And then the executor is what we call a personal representative of the decedent. They also stand in the shoes of the decedent in that sense, but they're doing it under authority granted to them by the court after somebody dies, versus a power of attorney who's given authority by the principal during lifetime. So that's the main distinction between a power of attorney and an executor under a will, or a power of attorney and a trust.
So one thing that we do see in our cases from time to time is a bad acting child who is the power of attorney for assets, and it's a durable power, and the mom or dad has become incapacitated, and the bad acting child uses that power of attorney to amend a trust document and give everything to themselves in exclusion to the other kids. What do we do in a case like that?
So there are times when somebody holding a power of attorney can amend a trust, but there's two requirements, or really three requirements, but two in particular. So first of all, the trust document has to allow amendment by a power of attorney. It has to actually say that in the trust. And then the power of attorney has to give the power to amend a trust. So you have to have that language both in the trust and the power of attorney. If it's missing on either one of those documents, it doesn't work. You cannot amend with a power of attorney. But there's a third prong to all of this, even if you have that language in trust and the power of attorney, which is your fiduciary duties. So an agent is not allowed to exercise a power of attorney for a principal that benefits themselves. Now, if they're amending the trust because there's a tax implication, maybe there'll be a bad tax result if we don't amend this trust, or there's something that benefits the principal by amending, then that's all fair game. But when an agent under a power of attorney uses that power to just give everything to themselves, that's going to be a violation of their fiduciary duties. And that's something where the other beneficiaries who've now been excluded could come in and take legal action to try and reverse that.
All right. So I think I understand that powers of attorney, after somebody dies, they shouldn't be used.
Yes.
They would be fraudulently used if they were used after somebody passes away. And then really what matters after somebody dies is the will and the trust, and primarily the trust if there is one. And then if some power of attorney during their lifetime took advantage of mom or dad by using a power of attorney to change a trust, then that's something that could be addressed with a court.
And it is actionable and something that could be sued on.
All right. Thank you, Keith.